Hello, good evening everyone. Tonight we are going to deliver a third PowerPoint presentation lecture for the coverage of midterm. And this is the continuation of the negotiable instrument law lectures. But before we continue our lecture, we would like to give credit to the following researchers: Len Francis Garque, Tricia Galola, Jusit Krisha May Galvez, Aisa May Gimao, Ana Herolaga, Siti Gumao. Now, as usual, as part of our tradition during my lecture, we give pre-test or post-test questions. And these are the question. Number 1, give at least 3 effects of dishonor. And then what are the effects of forgery? Then what is a real defense? What is a personal defense? Fourth question. Number 5, give at least 2 conditions of holder in due course. Give at least 2 rules in relation to forgery. That is question number 6. What will happen if the payee's endorsement was forged in a check? What is the section 22 of if the defense of the parties? 9. When is it considered a dishonored by non-acceptance? Number 10 question, when is it considered as dishonored by non-payment? Okay, let us answer these questions. Number 1, give at least 3 effects of dishonor. 1, when it is dishonored, it is compulsory for the holder to give notice of dishonor to every party against whom he intends to proceed. Number 2, a holder of the instrument has to give the notice. And number 3, notice is given to all the parties. It may be given to endorser or agent. Number 2, what are the effects of forgery? Answer: when a signature is forged or made without the authority of the person whose signature it purports to be, it is wholly inoperative, and no right to retain the instrument or to give a discharge therefore, or to enforce payment thereof against any party thereto, and can be acquired through or under such signature unless the party against whom it is sought to enforce such right is precluded from setting up the forgery or want of authority. Number 3 question, what is a real defense? A real defense is a defense that attaches to the instrument on the principle that the sought to be enforced never existed or there was no contract at all. Number 4, what is a personal defense? Answer: a personal defense is a defense which grows out of agreement, renders it equitable to be enforced versus the defendant. Number 5 question, give at least 2 conditions to become a holder in due course. 1, the documents must have been accepted for its value, and it has been accepted in good. Number 6 question, give at least 2 rules in relation to forgery. Answer: only the forged signature is wholly inoperative, not the instrument itself, and not the genuine signatures. A forged endorsement in a promissory note is inoperative. The maker can raise defense against the holder. Number 7, what will happen if the payee's endorsement was forged in a check? The drawee bank cannot debit the drawer's account, and that loss shall be borne by the drawee bank. Number 8, what is the section 22 of the defense of the parties? Proper litigant. Any court may authorize a litigant to prosecute his action or defense as a pauper, upon a prior showing that he has no means to that effect by affidavit, certificate of the corresponding provincial, city, or municipal treasurer or otherwise. Such authority, once given, shall include an exemption from payment of legal fees and from filing appeal bond, printed record, and printed brief. The legal fees shall be a lien to any judgment rendered in the case favorably to the pauper unless the court otherwise proves. Question number 9. When is it considered a dishonored by non-acceptance? When a drawee or one of the several drawees not being partners makes default in acceptance upon being duly required to accept the bill, or where presentment is excused and the bill is not accepted. Number 10. When is it considered as dishonored by non-payment? Answer. When the maker of the note, acceptor of the bill, or drawee of the check makes default in payment upon being required to pay this. Okay, let us now discuss further. Let us discuss dishonor of negotiable instrument. You see, dishonor means not honoring the obligation. A negotiable instrument may be dishonored by 1 or A. Non-acceptance. Non-acceptance, a bill of exchange is said to be dishonored by non-acceptance when the drawee or one of the several drawees not being partners make default in acceptance upon being duly required to accept the bill, or where presentment is excused and the bill is not accepted. I. When the acceptance of the bill is not done within 48 hours from the time of presentment for acceptance by the drawee. When the drawee is a fictitious person and cannot be traced, that is found in section 61 of the NIL. And when the drawee is incompetent to contract, or when the drawee accepts with qualified acceptance, and when the drawee, number 4, is insolvent or dead. And then, when the acceptance of the bill is not done within 48 hours from the time of presentment for acceptance by the drawee. And then, when drawee is fictitious person and cannot be traced, as in the case of section 61, when the drawee is incompetent to contact, when the drawee accepts with qualified acceptance, and when drawee is insolvent or dead, the bill may be treated as dishonored by non-accept. By non-payment, a promissory note, bill of exchange, or check is said to be dishonored by non-payment when the maker of the note, acceptor of the bill, or drawee of the check makes default in payment upon being duly required to pay the same. When it is duly presented for payment and payment is refused or cannot be obtained, or when presentment is excused and the instrument is overdue and unpaid, and when the acceptor fails to pay when it is due, and when the banker refuses to pay the check, is dishonored by non-payment, maybe the bill may be treated as dishonored. Effects of dishonor. When a negotiable instrument is dishonored either by non-acceptance or non-payment, the holder has all the rights to sue the parties liable to pay. It is compulsory for the holder to give notice of dishonor to every party against whom he intends to proceed. The holder of the instrument has to give the notice. And notice is given to all parties. It may be given to endorser or agent. And the notice may be in oral or in writing. It must be sent by post office. And the notice should be given in a reasonable time. And that, except in cases where which notice is dispensed with, Section 98 is to discharge all parties who are entitled to such. Okay. What are the requisites of a holder in due course? A holder in due course is a holder who has taken the instrument under the following conditions. 1. There cannot be any clear proof of forgery or unauthenticated action of the negotiable document or instrument. Number 2, the document must have been accepted for its value, and it must have been accepted in good faith. And when accepted, the holder must not be aware of any default, and it cannot have been an unauthorized signature or have been altered in any way, and that it is complete and regular upon its face. These are, and then there cannot be any current disagreement over it. Those are the requisites to become a holder in good faith. Let us talk about defense of parties. This is section 22 of the NIL. Let us talk about pauper litigant muna. A court may authorize a pauper litigant to prosecute his or her action or defense as a pauper upon a proper showing that he has no means to that effect by affidavit, certificate of the corresponding provincial, city, or municipal treasurer or otherwise, and such authority once given shall include an exemption from payment of legal fees and from final appeal bond, printed record, and printed brief. The legal fees shall be alien to any judgment rendered in the case favorably to the pauper unless the court provide otherwise. And then, what are the kinds of defenses? Real defense is a kind of defense which attaches to the instrument on the principle that the sought to be enforced never existed and that there was no contract at all. What is a personal defense? It's a defense that is growing out of agreement and renders it inequitable to be enforced by defendant. What are examples of defenses? Illegality, incapacity, forgery. Now, real defenses, minority, which is only available to minors, non-delivery of incomplete instrument, material alteration, forgery, ultra vires acts of the corporation, fraud in factum or in easy contractus, illegality if declared void for any purpose, vicious force or violence, want of authority, prescription, discharge in insolvency. These are real defenses. Then let's come to personal defenses. Personal defense is failure or absence of consideration, non-delivery of complete instrument, conditional delivery of complete instrument, illegal consideration, fraud in inducement, filling up blank not within the authority, duress or intimidation, filling up a blank beyond reasonable time, want of authority, transfer in breach of faith or trust, mistake, antedating or post-dating for illegal or fraudulent purpose. Those are personal defense. Now let us talk about forgery. What are the effects of forgery? When the signature is forged or made without the authority of the person whose signature it purports to be, it is wholly inoperative, and no right to retain the instrument or to give a discharge therefore, or to enforce payment thereof against any party thereto, and can be acquired through or under such signature unless the party against whom it is sought to enforce such right is precluded from setting up the forgery or want of authority. Now, what are the rules in relation to forgery? 1. Only the forged signature is wholly inoperative, not the instrument itself, and not the genuine signature. What else? In case of forgery of an endorsement, of an instrument payable to order, it is not only the person whose signature was forged who would not be liable, but also the parties prior to such person. Payment under a forged endorsement is not the drawer's order. Cut rule. Parties prior to the forgery are generally cut off from the parties after the. Now, number 3, despite the forgery of the signature, there may be parties who shall be free from setting up forgery or want of authority and are therefore liable, such as 1. Those who warrant the genuineness of signatures, like the acceptor or endorsers after the forgery. 2. Those who ratify the forgery, whether express or implied, and those who were negligent. And in one case, the drawer was not allowed to recover his signature was allegedly forged because it was established that the person who encashed the check was his trusted secretary. The drawer's negligence was considered the proximate cause of his loss because he entrusted his bank checks and credit card to his secretary. He also entrusted his secretary the verification and reconciliation of his accounts and did not personally check his statement of accounts, and canceled or used checks as the same were also entrusted to his secretary. Number 4, a forged endorsement in a promissory note is inoperative. The maker can raise defense against. Number 5, if the payer's endorsement was forged in a check, the drawee bank cannot debit the drawer's account and that the loss shall be borne by the drawee bank. This is cited in 1982, 1983, 2008, and 2011 bar exam. The rule applies if there are 2 joint pays but only one endorsed. In the case of Metropolitan Bank and Trust Company versus BA Finance, decided on December 4, 2004, and it also went out. It has also been asked during the 2008 bar. The depository or collecting bank is liable to the drawee in case of forged endorsement because it guarantees all prior endorsement. The collecting bank assumes all warranties of the general endorser. It's found in 1983 bar. 1. The collecting bank can in turn collect from its depositor. The person who deposited who endorses the check when making the deposit is liable for the warranties under Section 66, including the warranty that is valid and subsisting. It is asked in 1976 bar. Number 2, this is subject to the qualification that the drawee himself was not negligent or guilty of such conduct as would stop him from asserting the forged character of the endorsement as against the drawer. And then, in another case, the Supreme Court explained that only the drawee may be held liable if it was not established that the check containing forged endorsements passed through the alleged collecting bank. That can be confirmed in the Traders Royal Bank versus RPN Incorporated et al. GR number 13510, decided on October 10, 2002. The drawee in this case encashed checks, one of which is crossed, presented by unknown persons, although said checks were payable to BIR. Hence, the drawee was clearly negligent in encashing the check. Number 6. If the signature of the drawer on a check is forged, the drawee cannot charge the account of the drawer, and the drawee cannot recover from the collecting bank because the drawee bank assumes all warranties of an acceptor after payment, including the warranty and that the drawer's signature is genuine. It was asked during 1977, 1987, 2004, 2012, and 2015 bar. Number 7. If the check is deposited in an account of a person who is not the payee without authority, the drawee cannot debit the account of the drawer. The collecting bank is liable even to the payee and the drawer. It's found in the case of BDO Unibank versus Lao, number 227007, cited on June 19, 2017, and was also cited in the case of Metropolitan Bank and Trust Company versus Junel's Marketing Corporation, GR number 235511, decided on June 20, 2008. And then, that's all for the lecture for our third PowerPoint presentation in continuation of the negotiable instrument law. Thank you and good